Hi, everyone. My name is Noël Hutton. I am an organizer with the Trade Justice Education Fund, and I will be the one moderating today's briefing about Big Tech's digital trade agenda and its potential impacts on data privacy, especially given the Supreme Court's recent decision to overturn Roe v. Wade. And so just a quick heads up that we will be recording this briefing, and it'll be posted on our website and sent to everyone who registered. We'll also save some time for a couple questions at the end, but if you do have questions throughout, you can feel free to just put those in the Q&A function at the bottom of your screen throughout, and we'll get to them at the end. So in case any of you didn't already know, this is actually the second in a series of 3 digital trade briefings that Trade Justice is hosting this fall. And you can find a recording of the first briefing, which was on digital trade and labor issues, on our website at tradejusticeedfund.org. Also, 2 weeks from now, on October 12th, once again at 1 p.m. Eastern Time, we'll be focusing on digital trade and racial justice issues. So I encourage folks to register for that today, and you can find those details at our website, but we'll also be sure to get that link posted in the Zoom chat later on, and I think it should be there right now. So for today, I am really grateful to be joined by 2 excellent presenters, Jaya Aiyer from UltraViolet, who will be speaking about the increased importance for data privacy for people seeking, providing, or otherwise assisting with abortion services. And then to connect that back to trade policy, we have Lori Wallach here, who is the director of the Rethink trade program at the American Economic Liberties Project. And thank you so much both for being here. But before I introduce those 2, I'm just going to set a bit of context for this discussion today. And so in recent years, as the United States and really the entire world have begun grappling with how best to regulate big tech in areas including consumer privacy, algorithm discrimination, gig economy worker protections, antitrust, and more, many people don't know that corporations have been quietly pushing for the adoption of these so-called digital trade rules. And these are rules that would lock in bad digital governance policies and restrict new forms of regulation. And those corporate lobby groups are pushing to include these sorts of deregulatory measures in a whole host of new trade deals, but starting first with the Indo-Pacific Economic Framework, known as IPEF. And really that would be a huge deal because IPEF itself would set rules governing approximately 40% of the global economy. But not only that, Big Tech is also pushing its agenda through the America's Partnership for Economic Prosperity, the US-EU Trade and Technology Council, and the US-Kenya Strategic Trade and Investment Partnership. So in other words, tech companies right now are secretly pushing to limit all kinds of consumer privacy protections in wide swaths of Asia, the Americas, Europe, Africa, and of course here at home through these trade deals. And allowing them to accomplish this poses us all a really major threat. Because I'm sure you're all well aware, every move on the internet and via our cell phones are increasingly being tracked, stored, bought, and sold, as are our interactions with devices like Alexa and Google Home and others. And these are devices that many people may not even be aware are tracking them. And many of the ways in which we are tracked really don't give us any feasible way to opt out. And for this reason, we really cannot allow IPEF and all these other pending trade deals to restrict governments from acting on our behalf and establishing the sorts of rules activists have been fighting for, regarding under what conditions our personal data may be collected, where it can be processed or transmitted, and how or where it is stored. Additionally, state governments and others are increasingly turning to private corporations for their data tracking and analysis, including for predictive policing, for surveillance and other law enforcement functions. And we really can't allow trade deals to repurpose trade secrets rules or establish any other rules that would allow corporations to evade liability for any discriminatory or otherwise harmful source codes and algorithms. And so, as we started discussing in our previous briefing, and we'll continue discussing in our next one, these issues are really important for a whole lot of different reasons, because they impact how people are treated at work, and they impact the day-to-day survival for communities of color, and they impact a whole lot more. But for today, we're going to be discussing these issues specifically in the context of reproductive justice. And to get us started, I am very pleased to turn things over to our first speaker, Jaya, the campaign manager from UltraViolet. So Jaya, thank you so much for being with us, and please take it away.
Thanks, Noël. Hi, everyone. My name is Jaya Aiyer, and I'm the campaign manager at UltraViolet. I work on our disinformation platform accountability work, and that, of course, feeds into data privacy. So I'm going to just share my screen, so bear with me. But yeah, so I'm going to be talking about abortion care, tech accountability, and data privacy in a post-Roe world. Again, my name is Jaya. This is my email if anyone wants to reach out to me after the conversation, or if you want to follow me on Twitter or Instagram, you can take down my socials. I work with UltraViolet. UltraViolet is a feminist and gender justice organization. We're a community of 1.2 million strong that drives feminist cultural and political change through people power and strategic advocacy. UltraViolet actually just celebrated its 10-year anniversary last week, and we're really gearing up this over the next few weeks to focus on the election, and also think through policy and how policy, specifically around tech accountability and data privacy, intersect with abortion care and reproductive justice. So that, is what brings me here to our conversation today. So I'm just going to set the stage, kind of give you a context for where UV is in this conversation. In November 2021, so almost last year, we released a set of policy recommendations and a report card to the platforms. Through our analysis, working with partner organizations, we identified and came to the realization that social media is not a safe place for Black, Indigenous, Asian, American, Pacific Islander, Desi, Latinx, women of color, and LGBTQ folks, and much, much more, of course. Equitable and human-centered moderation and policies are key to ensuring platform safety for all users, not just the privileged few. Big tech has failed the test when it comes to creating an internet experience that is safe and inclusive for Black women, women of color, and LGBTQ people. These companies continue to fail when it comes to protecting user information and data and ensuring privacy. So the policy focus areas that we really delved into in our report were focused around user policy and hate speech, disinformation, defamation, and the promotion of extremism, enforcement and transparency for survivors of harassment and hate, and internal platform policy and culture. While this report is so our policy focused on these 4 demands, and a report card that we created also included grading existing policies against our recommendations. While this is now nearly a year old, there have been some updates to platform policies. With the Dobbs decision and the overturning of Roe, the need for data privacy and platform transparency is now urgent more than ever, particularly as it connects to abortion care and people seeking information online about abortion care. You can check out our policy recommendations and report card by visiting feministnet.org, and I think Noël is going to pop that into the chat at some point. So with that kind of setting the stage, I'm going to jump into what we're all here to talk about, big tech, reproductive access, and disinformation. So while some big tech companies following the overturning of Roe signal support for abortion rights in recent months, their established record proves that they are not committed to reproductive justice at all. Fake abortion clinics run by anti-choice groups designed to entrap visitors are known to show up on Google searches, on ads are placed on Facebook, Twitter, Instagram. TikTok has numerous videos of anti-choice or anti-abortion advocates creating videos, spreading mis and disinformation. And so it's really easy for people to fall victim to these lies and this disinformation online, and big tech really isn't doing anything about it. YouTube recently, after we sent a letter to various big tech platforms calling for big tech to remove and ban content promoting disinformation around abortion care, YouTube finally agreed to remove ads and content around abortion mis and disinformation, but they're still allowing crisis pregnancy centers, which are kind of fake abortion clinics, to place ads online. And we're still waiting to see kind of what the impact is of YouTube making this statement, to see what the real, if they're creating those results. After the Supreme Court's decision to overturn Roe was leaked, representatives from Facebook and Google did not respond to reporters' inquiry regarding how or if and how they would safeguard the privacy of people seeking abortion care. Ongoing mis and disinformation about the safety and validity of medication abortion is also undermining the authority of and trust in the Food and Drug Administration and causing dangerous misuses of these pills. Content on major social media platforms is proliferating online with inaccurate information and inappropriate information, encouraging people to disregard the FDA-approved regimen for abortion using these medications, and instead to use them in ways that put people at risk for serious complications. So why data privacy? I can imagine it's surprising that a gender justice organization would be investing time, energy, and money into data privacy, into the fight around data privacy, but it is so deeply connected to gender justice. As we've seen more recently, data miners and data brokers are really making it possible for users who are operating online, looking for accurate care, seeking out services. Data mining and data brokers are making it possible for them to no longer be safe, to potentially have their search history, their messages turned over to law enforcement, and then being served and having to go through the process of prosecution around violating state laws around abortion access and care. This is ridiculous. And the fact that we don't have data privacy laws and regulation in place to address this really critical issue, especially following the overturning of Roe and the loss of this fundamental right, is really concerning to us as a gender justice organization and to the broader abortion rights movement. So data privacy and reproductive health, again, really go hand in hand. These can be seen in issues surrounding period tracking apps, data brokers and personal data, search engine history, and precise location tracking being sold, and unencrypted messages essentially being the standard on social media platforms. So menstrual cycle data collection via popular tracking apps like Flow pose a grave threat to abortion patients. In 2021, the FTC settled with the popular app Flow, which disclosed user-sensitive health data to a third-party actor, including Facebook and Google, despite promises to protect user security. Following the overturning of Roe, apps like Flow have stated commitment to ensuring encryption and ensuring their apps are safer, but the research is really showing that these commitments aren't keeping pace with the ways in which data brokers and law enforcement are trying to use this data. And it's a real fundamental safety. I use a period tracking app, and it's terrifying to think about the fact that were I to say not live in Massachusetts and were to live in a state that doesn't allow abortion, I would be at risk. I would be at risk of being arrested or having law enforcement track my data. The second point that I brought up is around data brokers and mining. In the absence of rules regulating the collection and use of personal data, tech companies and data brokers have built lucrative business models off of collecting troves of personal data about each one of us, and often disclose the personal data to third-party bidders. The unrestricted collection of data about users' most sensitive activities, including their search histories, location, and more, will make tech companies targets for law enforcement agencies in states that criminalize abortion, placing those patients at risk for prosecution. In July, the FTC actually released a statement regarding location, health, and other sensitive information. The commission stated its commitment to fully enforcing the law against illegal use of sharing of highly sensitive data, particularly data concerning or connected to products that track women's periods, monitor their fertility, and oversee their contraceptive use, or even target women considering abortion. But we need legal action. We need Congress and the Senate to work on this as well. It can't just be housed in the FTC. And finally, I'm sure many of you have heard about this horrifying case in Nebraska where a mother and daughter's unencrypted messages that they had shared on Facebook Messenger were actually used against them, and law enforcement used those messages to arrest and prosecute the mother and the daughter for seeking out abortion care. This can't be the norm. Like, this cannot be the norm in our society, but unfortunately it is. And the fact of the matter is, while the policies around encrypted messaging with platforms is tricky, and there's a lot of nuance that needs to be processed in implementing, without having protections like Roe in place, messages, Facebook messages or other messenger apps are going to become a space for people to share resources and information if they are in states that don't allow abortion care. And so platforms and regulators really need to think through how to ensure that messages are safe, and that users are protected when they're interacting with the platforms. So that is my piece. Scan this QR code or go to feministnet.org to learn more about our disinformation work and join our campaigns. And I hope this was really informative. Again, feel free to reach out to me if you have any questions or would like to learn more about this work. And thank you so much, Noël and Hillary, for having me.
Great. Thank you so much, Jaya. That was really such a clear presentation about UltraViolet's work and why data privacy protections are really ever more important in this new context that we're living. So for folks watching, just a quick reminder that we're going to hold off on answering any questions until the very end. But that said, if you'd like, please do feel free to type your questions in using the Q&A link at the bottom of your screens. But for now, to discuss how data privacy, data security, algorithm transparency, and all these related issues could be affected by new digital trade proposals, I'm going to turn things over to Lori Wallach, the head of the Rethink trade program at the American Economic Liberties Project. And Lori has been a leader in trade justice organizing for many decades and is a senior advisor to the Trade Justice Education Fund. And lately, she's been one of the most powerful voices sounding the alarm about the dangers of big tech's trade agenda. So, Lori, thank you for being here, and go ahead.
Thank you very much, Noël, and hello to everybody. I'm going to put up some slides. Let's see if I can pull this off. There we go. Can you see everything? Yep, hopefully. All right. So I'm going to give a little bit of background just so everyone's situated, because a lot of people are probably thinking, how the hell do trade agreements have anything to do with the issues that, for instance, Jaya just described. And hopefully, no one's going to start crying thinking they're back in a high school economics course. But remember how trade agreements originally were about trade. You probably heard about the GATT, the General Agreement on Tariffs and Trade, and all that stuff that came from the Bretton Woods Conference. So that was the, real global rules. The General Agreement on Tariffs and Trade in 1947 covered border taxes and some basic rules on actual trade, stuff that went between countries. And that's frequently called the Bretton Woods era. And that was from World War II until the 1990s. And then we start to see a hijack by corporations of trade agreements, such that what was this old system becomes the WTO and the NAFTA or CAFTA, a whole set of trade agreements. And they have all these other kinds of rules. The one I'm going to spotlight is one that's called TRIPS, Trade-Related Intellectual Property. This is the classic example of having secretive, closed-door negotiations captured by an interest to actually establish binding rules that are the antithesis of ostensibly the subject matter. So free trade, we all know, competition, except that trade-related intellectual property rules that the WTO enforces, it's monopolies. It's actually intellectual property monopolies. It has nothing to do with cross-border trade. It has nothing to do with any kind of trade. It just literally is big pharma managed to hijack negotiations and got a chapter for themselves that requires all the countries in the agreement to impose monopolies for them, which is part of how they've gotten away with such high medicine prices, totally unrelated to trade. And that is the place where we enter the Indo-Pacific economic framework. It's unclear what exactly it's going to be just yet. Is it going to be one of those same old trade agreements, or is it going to be something different? But we know there's some features that are worrisome. The main thing to remember about all these past agreements, and that's threatening about IPEF, is it's not really actually mainly about trade, but it's really a system of enforceable governance. And when it's promoted and controlled by large corporations, it becomes very dangerous. These kinds of rules that will be established in IPEF not only would cover 40% of the world's economy, so that many people, that many countries, it's 14 countries total with the US, but also those rules, when they're negotiated between countries, aren't subject to change except by consensus of all the countries. So it's like pouring cement over the moment at which you write the rule. All right, so these agreements basically set constraints on domestic law. They're not about trade per se. And each of these agreements has something like the language there from the WTO. Each member shall ensure the conformity of its laws, its regulations, and administrative procedures with its obligations as provided in the annexed agreements. So what this means is if an agreement like IPEF has a rule that forbids limits on the free flow of data, yet there's a requirement, for instance, that companies get rid of data that's private, or they don't allow it to be exchanged, or they have to be able to be investigated by a regulatory agency about what they've done with the data. If it's free flow, then the domestic law, keeping the data safe, and the international obligation conflict. And the shall ensure goes to the fact that these are enforceable rules, and countries that violate the rules can face trade sanctions. So particularly as you think about this, it's not like trade between nations. It's like a form of diplomatic legislating, where number one, in the US, 600 official corporate advisors are helping set the rules. 500 of them are corporate. The negotiations have been worryingly confidential, secretive. In the past, that's true. They're starting to look that way with IPEF. But these are enforceable rules that have nothing to do with trade, which gets to big tech's goal with this, which is to hijack that closed door process to rig the rules. And it's basically setting up binding international rules that limit government action from either creating or maintaining domestic policies to regulate the big tech platforms, whether you're regulating them for privacy, whether you're regulating them for anti-monopoly, etc. And again, how the Trojan horse strategy works is the countries are required to conform their domestic policies to the international rules, or they face sanctions. So if you think about what the threats are, privacy and data security, I see a typo, are threatened in the US and globally. There is no real upside to these agreements. You know, it's not like you can have a fight over trade per se, where there are upsides and there are downsides, they're winners and they're losers. In this instance, the kind of rules that the big tech companies want to impose through these negotiations, there's no upside, not for workers, consumers, communities. It's all upside for them. It doesn't do anything to actually fix real problems, like the fact that Amazon brings in tons of stuff from China and sneaks around inspection by using a particular loophole. This is just about limiting what regulatory agencies and Congress can do. So they can keep, the big tech guys can keep their crazy wild, wild west business model and exploit our personal private data for their profits. I put in the other things that this is about, because while it's scary as hell in a post-Roe world, vis-a-vis our privacy, tracking where we are, what kind of websites we're looking at, what kind of data we're putting there, it's also very important to understand that this agenda is about big tech trying to protect their monopoly power, to continue to crush their competitors, to jerk around gig workers. It's also about having incredible secrecy, because they get extra protections around artificial intelligence, code and algorithms. So all the stuff that governments are looking into about racial discrimination, violence, incitement of violence, you can't get information about what the code and the algorithms are. As well, it's a big digital offshoring boon, where basically it is possible to relocate jobs if you don't have to have privacy rules related to those jobs enforced, to say nothing of evading liability for things bought online. And the idea is to basically get ahead of any of these things being done in the US, because we're behind the curve, and then to make sure the rest of the world has to roll back the standards they have. So we're going to share these slides because this is a lot to take in. But if you look at each of the kinds of provisions that have been in these past agreements, and we understand for IPEF, they want to start working off of one of those agreements called the US-Mexico-Canada Agreement, the revised NAFTA. You have this free flow of data and no data processing or storage localization rules, which obviously undermines privacy, data security, et cetera. You have trade secrets protection for code and algorithms. All of these different pieces, some of which we don't have to get into in detail, are threats to policies entirely unrelated to trade, but that have to do with trying to get big tech on a leash. So as a recovering trade attorney, I could not, but just because you guys probably are all thinking, Jesus, she's got to be exaggerating, I thought I'd share you some text. So here is the actual text I'm talking about cross-border transfer of information and location of computing facilities. This is from the revised NAFTA, the USMCA. So it creates an absolute right for big tech to control the data, and we're supposed to conform our domestic laws to it. So no party shall means absolute enforceable. No party shall prohibit or restrict the cross-border transfer of information, including personal information, by electronic means if this activity is for the conduct of the business of a covered person. A covered person just means a company in a country that's part of the agreement. This article does not prevent the party from adopting or maintaining a measure inconsistent with paragraph 1. That is necessary, red flag in the word necessary, I'll get back to that, to achieve a legitimate, red flag in the word legitimate, public policy objective, provided that the measure is, and then those next two things are trade code words for basically you can never do it, is not applied in a manner that would constitute a means of arbitrary unjustifiable discrimination or disguised restriction on trade, does not impose restrictions to transfers of information greater than are necessary to achieve the objective. Now, who gets to decide all that, right? A lot of subjective stuff in there. A tribunal of 3 trade officials is the past model. So article number 1 says you can't limit any of this stuff. And then article number 2 says basically nothing if you read trade jargon. So necessary is a standard that's almost impossible to meet. It's sort of what that part B is. You have to prove a negative, that there is no less trade restrictive way to do it. To put this in perspective, in trade disputes in front of tribunals, if it's a necessary test, you almost never win defending your domestic policy. What is a legitimate public policy? You can imagine an administration that would not consider legitimate public policy be protection of women's abortion access or health rights. And then, provide the measure is not applied. That phrase A and phrase B are part of WTO language, where of 50 attempted uses, there have been success twice to get through that standard, because who the hell decides what to disguise restriction on trade? Or who decides what's greater than necessary? 3 trade officials whose job is to get rid of basically domestic laws that conflict with the trade rules. Then you look at Article 1912, its location of computing facilities. No party shall require a covered person to use or locate computing facilities in the party's territory as a condition for conducting business in that territory. Now, what the actual hell does that mean? So first of all, it undermines privacy. So you basically think about the laws that have, say, a right to be forgotten or a kind of privacy protection. Once the data is offshore, the company in the US on which that legal obligation binds is in a position basically of saying, yes, when I had it, absolutely, I would have deleted it, or I'll delete my copy, or of course I'm keeping it secure. No, I'm not giving it to anyone. But once it's offshore, or it's with a data broker offshore, maybe even a data broker offshore that's owned by that same company, by the way, but incorporated someplace else, it is basically impossible to compel the company to meet the standard in the domestic law. So one thing that struck me in looking at the My Body, My Data draft that was submitted and is pending, that and any other data policy enforcement rules, is that if the data is out of the US, how do you make sure you can get rid of copies? How do you make sure it's not being given one way or another to someone who's not supposed to have it? Now, this is a very tricky subject, right? I'm not saying it's easy, because you need to have privacy so civilians don't have their health and their location information tracked. At the same time, there are obviously legitimate ways that you want to be able to, track someone who has just blown up a building, etc. So the difference, though, of how you do that in part relates to maintaining access to the data. And if there's an absolute right to take it offshore, then you just try and take it to someplace that doesn't have any of those kind of obligations. So it's just cheaper to comply with. As well, this absolute right of flow undermines jobs, it undermines regulatory capacity. Now, I want to flag that one with respect to all the issues around reproductive rights, because basically it helps a company that doesn't want to meet the rules to be able to do this like so sorry, not sorry excuse. And there's we don't have the data, would help you, but we can't. Or yeah, we did it while it was here, but we're not liable for what happens when it goes offshore. In all of these policies, when I'm talking to members of Congress, I'm saying add a thing that makes them liable when it goes offshore, or make them keep it here, because otherwise you can't stay on top of it. And in fact, the Trans-Pacific Partnership had a carve out for free flows for financial information after one of the high-level Treasury officials found they could not literally get the banking information during the global financial crisis to figure out who the hell did what to whom. Because the bank said, oh yeah, we don't have that anymore. And oh yeah, we can't get back to that. So sorry, we can't show you what those trades were. Real story, actually has happened. The other issue to keep in mind is the source code and algorithm privacy provisions. So here, no party shall require the transfer of or access to a stored code of software owned by a person of another party, so someone from the other trade partner, or an algorithm expressed in the source code as a condition for the import, distribution, sale, or use of the software or products containing that. And then the exception. This does not preclude a regulatory body or judicial authority of a party from requiring a person, blah, 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 to preserve and make available the source code or an algorithm expressed in that source code to the regulatory body for, weasel word, a specific investigation, inspection, examination, enforcement action, etc., subject to safeguards against unauthorized disclosure. Now, what's the problem there? It guts enforcement and oversight. it basically says, now keep in mind that word specific, the government basically has to make a showing of a violation so that they're doing a specific enforcement action. So before you can get the information to find out a company is breaking the rule, you have to get the data, but you can't get the data to show they're breaking the rule because you can't get the data. You can't get the source code. You can't get the algorithm. And if you look at My Body, My Data, for instance, basically, if the data has to be stored here, if the data is not required to be stored here, and you can't get the code to figure out what processing happens, you basically, again, have no idea of what has happened with the information. There are obviously really serious problems with civil rights violations separately, because all of the policies now being considered for artificial intelligence non-discrimination require review of source code, review of algorithms, review of the data sets used for artificial intelligence to make sure they're not built-in discrimination with respect to housing or employment or financial loans, etc. And then basically, if you look at a bill like the American Data Privacy and Protection Act, the grand privacy protections bill that was passed out of the Energy and Commerce Committee with bipartisan support, that has a whole section on algorithm and code pre-review for civil rights and other violations. You could never get your hands on it. So I'm going to stop there, just giving folks a little bit of a tour of exactly what in the rules of these past agreements could undermine our privacy, the ability to have policies that would importantly ensure that the kind of laws to guarantee privacy of our health information and our location information are actually enforceable. You can see from these past agreements, we definitely don't want to replicate that in the IPEF, but of course, big tech is going to use all of its money, all of its lobbyists to try and lead the big coalition of corporations to do exactly that. And so you don't have to give a whit of care about trade. The question is, are you going to have democracy, privacy? Are you going to have the big tech monopolists running the show using their power? Or are we going to have the rules set to suit us and regulate this next set of interests? Or are they going to get away like Big Pharma did in using trade agreements, hijacking them, rigging them to handcuff Congress and regulatory agencies and basically to strangle democracy? That's what we're up against. There can be rules in the IPEF that are even about digital issues that actually fix the real problems. But what sure as hell can't happen is a replication of those old rules. Thank you all very much.
Great, thank you, Lori. That was really helpful. I hope that it helped a little bit to tie these issues together. So actually right now we're just going to transition into the final portion of the webinar, which is I'm going to open it up to a few questions. And if you do have a question, you can use Zoom's Q&A function, which is probably at the bottom of your screen if you're on a computer. If you're on a phone, you might need to press the little 3 dots button to access. Let's see, I had one that come up first, but I think this one would be directed at you, Jaya. How has reproductive justice organizing had to shift with post-Roe scrutiny? And such as how are people moving differently now that their data is being collected and birthing people are being so closely monitored?
Yeah, that's a great question. So it's definitely, of course, it's shifted. I think there's kind of like a twofold answer to this. Of course, in states where abortion rights have been enshrined in some capacity or another, pregnant people and people who are at risk of kind of complications when it comes to pregnancy and stuff like that are able to access their care at business as usual for the most part. Obviously, with using these types of apps, like period tracking apps or fertility tracking apps or things like that, I think the conversation has really shifted in the organizing space. In states where reproductive rights and access to care has either been fully stripped, extremely limited, then things have really had to kind of fundamentally shift. Of course, there have been abortion funds and networks that were in existence well before we were broadly having the conversation at the idea of Roe being overturned, but abortion funds are really, and independent clinics and other organizations, reproductive justice organizations in those states have really become leaders and resources to connect people who are seeking abortion care in states where it's not legal to places where it is legal. There have been efforts by states to create legislation and laws to ensure that people who are seeking abortion care from out of state can come to that state to get that care. I know California has implemented policy around that. Massachusetts is considering that and actively working on that. But I think with data privacy, the thing that's changed is that we're having these conversations much more openly. I think prior to Roe being overturned, honestly, like in my circle, I feel like because I'm in the data, the tech and accountability space, we were having these conversations. But outside of that, most people don't know what data mining is, that there's such a thing as that, and the fact that we kind of, I think, assume that HIPAA would extend to things like fertility apps, to your, that Facebook and Twitter and all of these social media platforms. The assumption is that they're encrypted, even though they're not. Right. The unique thing about WhatsApp is that it is encrypted messaging. Similarly, Signal is encrypted messaging. But I think everyday people aren't necessarily thinking about the fact that their messages are not protected and that they are not encrypted. So I think the big shift has really just been that, sadly, like, people are getting in the loop because there are terrifying cases like what happened in Nebraska, are becoming really real and a real possibility for a lot of people. And so within the RJ space, that really has been the big shift. Getting those resources to people and that information to people who maybe wouldn't know that beforehand, so that they know not to message people about abortion care on Facebook Messenger, things like that.
Right, absolutely. Thank you, Jaya. I think this one might be directed a little bit more towards Lori with the trade background. What can groups that work on reproductive justice issues do to make a difference on this issue regarding digital trade?
Thanks for that question. I think in response to that question, and the question that has also been asked, which was, is there anything to do to shape this, or do we just have to be against it? I think there are sort of three things we all need to do. The first thing is just to make people aware that this is going on. The IPEF itself, most people don't, they hear IPEF and they probably think it's like the newest iPhone or something. I mean, they have no idea that it is a threat that's happening, that's negotiation. And so one very important thing to do is to educate. And if you go to the Trade Justice Education Fund's website, there's a great one-pager on this threat. If you go to rethinktrade.org, our website, or go to my Medium posts or Wallach Lori on Twitter, we have a steady flow of fact sheets, memes, etc., just to help get the word out. And so, just some of the basics. We're about to put up for IPAF, for digital trade, a series on Facebook and through Twitter of images of what the threats are, just to start helping get through people's heads that this thing is going on and that this has to do with things like reproductive rights and privacy. It has nothing to do with the price of widgets. So that's number one. Number two is everybody has to simultaneously, while getting their friends and family educated and getting themselves educated, to be sending out the alert to Congress. This is a very tricky process because, heartbreakingly, so far, the Biden administration plans not to have Congress vote on this agreement. Yes, Article 180 of the Constitution guarantees an exclusive right of Congress to regulate trade with foreign countries. Yet there is an attempt to not have Congress pay attention to this. So given Congress has a lot of other stuff that is in front of them, there's not sufficient attention. So I would highly recommend, particularly if you have a member of Congress who's been involved in the tech issues. There are scores of House and Senate members who've said, I'm going to be the person who's going to fix privacy. I'm the one who's fixing monopoly. I'm fixing AI discrimination. Excellent. Make sure when you talk to your member of Congress, they realize that basically this Trojan horse is coming up behind them and is going to steamroller them in all of their digital governance initiatives. And then the number 3 thing to do is actually to stay connected. So sign up for the Trade Justice Education Funds, email blasts. Basically, we all will be knowing more week by week. This process has been so secretive that to some degree, it's our international counterparts. We're all together internationally. It's not, you know, a xenophobic, ooh, we don't want those people. It's no, we're all the people. We don't want those big tech corporations running the damn show. So we're all working internationally. And, you know, in the middle of the night, you might get a text because it's already the next day there from someone in Australia, New Zealand, or Malaysia going, holy beans, we just heard about this. What do you think about this? So if you stay in tune, sign up for Trade Justice Education Funds emails, then as we start to see the details, then there'll be actions. And CTC, the Citizens Trade Campaign, TJEF's activist co-partner, is going to be running and has been running great campaigns in this issue. So you actually can bind together with people around the 14 countries and make sure, to go back to that other question, that either we have the right rules or we have no digital agreement in IPAF. Those are our options. What definitely can't happen is more of the same.
Thank you, Lori. I think I'm just going to do one more before we wrap up. And I think Lori could probably answer a little bit of this one, which is, where does the Biden administration stand on data privacy issues? And for Lori in particular, specifically in the trade deals. So if either of you want to answer that one.
Yeah, I think given kind of how much stuff the Biden administration has been trying to push through, data privacy is definitely of importance, but there's a lot of trickiness kind of in getting that pushed through and passed. You know, I think about kind of I'm forgetting the name of the legislation, but there was a piece of legislation that was coming through Congress around data privacy. And given kind of the way that Republicans are acting around abortion and reproductive care, there's been a lot of hesitancy, unfortunately, to include reproductive health and care language and in any of these types of legislation. That's why Cantwell's my data, my choice was so important, but also sadly a big reason why it's kind of been in a standstill in a lot of ways is because there's been this hesitation to include this type of language, which is just, you know, really frustrating and not great, because it is really critical and it is really important. Of course, the FTC sued a data mining or data brokerage company in August. I'm forgetting the name of that company, but that is an example of kind of a federal body initiating conversation around this. But we do need, you know, the Biden administration to push forward with this type of work, and we do need people and our senators and our Congress people, like Lori said, who have been talking the big game about data privacy and tech regulation and stuff, to really own it and move forward and really acknowledge the fact that it's not just about the broad issue of data privacy, but it's about this nuanced thing of something so personal and intimate like your own reproductive health that needs to be protected and included in this type of conversation.
And I would just add that there are sort of two different levels of complexity. One is things that the executive branch can do and will lead or direct on, and then there's what Congress can do. For some of the things that we need, like real privacy protections writ large, we're going to need Congress to act. And that's going to take all of us fighting to get real privacy legislation passed over the objections of big tech and all their lobbyists and all their money, because there's certain discretion the executive branch has. So for instance, that wonderful case, the Kochava case is the case that Jaya was mentioning. That is the data broker that the FTC sued over selling and trading in geolocation information. So they've already started doing the thing that could really, you know, show you were near an abortion clinic, for instance, in another state, or whatever your, you know, crazy state that wants to ban abortion would want to get about you. So that kind of enforcement stuff already is happening under statutory authority that exists, and the FTC can say it's unfair. They have a broad statute, therefore it's illegal, and they have a strong case. But there's other kinds of data violations that, you know, unless there's new legislation, it's not really something the executive branch can do on their own. So for instance, right now, certain kinds of financial and certain kinds of health data is protected. Everyone thinks of like the HIPAA notice when they go to a new doctor, they get that thing they have to sign. That's because there's a law. But none of those apply offshore. So once that data goes offshore, it's wild, wild west time. And how that works with respect to like things you voluntarily sign up for that aren't exactly your confidential health from your doctor information. You know, these are laws that were before the era of thinking about all of this personal information being effectively voluntarily, not really, but you can't avoid it, sucked up out of you via, you know, your little phone. So then there is, so that's the defensive, like what can the government do absent Congress acting? Congress has to act. Then there's the what direction, and this gets the trade agreements, is the executive branch leading it. And there I'm afraid to report it's a split. So you have agencies that have been particularly savvy about privacy issues, so and monopoly, like the Antitrust Division at Judiciary or the FTC, certain other bodies. Some of the Labor Department folks are thinking about, you know, how do we do enforcement if we can't get information about bossware, for instance? So you've got agencies that are thinking about it in a sort of smart, defensive way. You also have the Commerce Department, where Commerce Secretary Gina Raimondo is, you know, very buddy-buddy with the big tech companies. She has a lot of very senior staff who are rotated from the big tech companies through the revolving door into key jobs in that department. She's been pushing the status quo. She wants basically the IPEF agreement to have all that old bad stuff, and has been the one leading the fight to make sure Congress has nothing to say. Then you have the U.S. Trade Representative's Office, which typically in the past has been with the Commerce Department, basically as a wholly owned subsidiary of all those corporations and the advisory groups. You have a USTR now that is very savvy about all the potential conflicts between the administration's antitrust declared policy, their anti-monopoly policies, government-wide initiatives, and privacy interests, and racial discrimination online, and women's health. Like, they are a USTR that, instead of just flacking for big tech, is very aware of all these issues and trying to figure out how to protect the domestic space. And then you've got certain countries that are in this negotiation that are in the sort of corporatist sphere. So like the country of Singapore has been pushing the most big tech friendly, outrageous rules for digital trade around the world. So all of that is why we the people going to live with the results, need to overpower that. I saw one in the chat, someone mentioned how people power stopped the Trans-Pacific Partnership, which had all of this stuff in it. And it's exactly right. It's like the Dracula strategy. Like, things that are this creepy and rotten don't do well in the sunshine. So we need to take this threat, drag it into the sunshine, and try and kill off the bad stuff. Could I give you an exposition of what should be in a good digital trade agreement? You bet. If you really want to get into that, go to my Medium posts and you can see more of what we have in mind. But we don't have to have these dangerous rules, but we're going to get them if we don't educate people, make people aware, and activate and advocate.
Great. Thank you, Lori. So unfortunately, that's all the time we have for questions today. But if any of you out there do have any other burning questions we weren't able to answer, you can definitely email them to us at info@tradejusticeedfund.org. We'll do our best to get those answered for you. And if you got something out of today's big tech digital trade agenda briefing, I do urge you to RSVP for our next webinar on digital trade and racial justice that will take place 2 weeks from now. Again, you can do that at our website at tradejusticeedfund.org. There's a link in the chat. You can also sign up for our emails, as Lori mentioned. And finally, I just want to again thank our excellent presenters, Jaya and Lori. We really appreciate you two being here and for your really essential work towards a livable future for birthing people. So thank you, everyone, and take care.